Well, it's really great to be here, and I feel that I've learned more by sitting here than you'll learn from hearing me. But it's fascinating, and now I have a lot of phone numbers for people to call when I have my next most difficult bail decision. The topic that I want to talk about is whether or not what lessons could be learned from the federal system. We're a very different system. I have a lot to learn from all of you, but our system has nowhere near the volume of the state system, and we have many more resources. I first realized that when I became a judge, and my wife, who is a state court judge at the time, came over to watch me when I was doing arraignments. And she looked at me and she said, it was one of my busiest days, and she looked at me and she said, "Oh, I shouldn't have come today. I didn't know you were closed." And she said, I just don't understand what's going on here. We don't have the volume that you do. I have the luxury of having bail hearings that can last up to a half hour, 45 minutes. We have resources that are incredible. When I get on the bench, I will have, from the Pretrial Services Office, I will have a 2 to 4 page report that will tell me all the criminal, financial history, medical history, a report on the people who are posting bond or potential suretors. I'll have half of the person's life story in front of them. And if I have questions, the pretrial services officers who have a 50-person caseload, which I think must be a real luxury for those of you in the state court system, I can ask them to please go out, do a home visit, let me know what the home is like, how stable the employment situation is. I can get so much information that I'm not really shooting in the dark. And in the absence of a crystal ball, this is really the second best. So what do we do in the federal system? One of the topics is big ideas. So what big ideas might there be? I'm going to talk to you for a minute about somewhat big ideas, but I think they're probably not ideas that you haven't thought of. What's really exciting today is that I think there are so many new ideas coming from the ground up and the top down in our criminal justice system, whether it be state or federal, that we're really, I think, on the verge of tremendous change. So for me, some of the ideas that are important in what I do are that, number one, money is not needed in most cases to secure appearance or to protect the community. And as a parenthesis, in the federal system, we do have detention based on a danger to the community, which you don't. So that means there are other grounds for detaining people, and that's a whole other story that the Supreme Court said it was constitutional to do that in the case involving Fat Tony Salerno, U.S. versus Salerno, and that's where we are with the Bail Reform Act. The second idea is that pretrial detention does not necessarily make us any safer. And I think if we have time, we can talk about that a little more, but I think you all know what that means. But you're more interested, I think, in the state court system in failure to appear. And for most defendants, we find, at least in our court, that there are conditions, most often not monetary conditions, that will secure people's appearance in court. So for example, we release about 60% of the defendants who appear before us, and that includes people at the lowest risk and at the highest risk. And we're able to do that, and we're hoping to do 70%. We think we can do better. But we're able to do that because we find that 0.4% of the people we release, and that's in the low and high risk categories, 0.4% fail to appear. It's just a small number. Now again, our population is different from yours. Sometimes the people with the lower level crimes are the ones who are more likely not to appear than the people with the more serious felony arrests. But that's what we find. And just in case you were interested, 2.2% of the people that we release are rearrested while they're on release. Again, a very, very small percentage, so that we find that the community is safe from is safe when we release people. Now, maybe that means that we're not releasing enough people because there are so few people that fail to appear and so few people that commit crimes. But this is also true for the high-risk defendants. The high-risk defendants, again, very few of them fail to appear. And the last of the two ideas that I just want to go over briefly is there are two ideas. One, you've probably heard this already, but it's something that our pretrial services officers talk about all the time. Change begins with crisis. That often if you want people to change their behavior and have new, different lives, perhaps more law-abiding lives, the best way to do that is to catch them at a moment when they're most vulnerable and most willing to accept change. And the second point, which is something which I learned by doing a reentry court over the last 5 years, and that's included people who were in prison for up to 18 or 20 years and were trying to find a way to get their bearings when they got out of prison. Reentry begins for many people on the day of arrest. And one of the things that I hadn't realized until I was involved in a reentry court was that we should start thinking about the person more holistically, looking at the longer arc of a person's rehabilitation from the day the person is arrested, or at least comes before the court, to the point where the person, if the person ultimately has to do time, the person comes out. If we can start some of the groundwork then. Now, how can we do that in a system that's basically a criminal justice system where we're judges, not social workers? And one of the answers, for us at least, is resources. We have two kinds of resources that make it easier for us to do what we want to do. And from what I've heard today, you have in the state system many of these resources, I've heard about a lot of them, that are exciting that we'd love to be able to use as well. But what are the resources? One major resource is our Pretrial Services Agency. As I mentioned, we have Pretrial Services officers who interview all the relevant people at the time of arraignment and give us a pretty good idea of what we're facing and what the defendants are facing if they're released. The advantage of having a pretrial service office is also that they can run a risk assessment. And I've heard something about risk assessment that you have in the state system. We have something called the PTRA, PTRA, which is the Pretrial Release Assessment. It was something that was developed by the Administrative Office of the Federal Courts. Our pretrial services people tell us that it's fairly accurate, that it puts people into 5 categories, the lowest risk being 1, the highest risk being 5. We judges don't ask and usually don't want to know what the risk category is that someone is put in, because we don't want the hearings to be based on a dispute over whether the person is properly in that category. But that risk assessment informs the decisions that the pretrial services officers make to us when we decide a bail issue. And having that risk assessment there, and if we want to, being able to find out more about it is useful. But again, it's only a general assessment. It's not necessarily, again, the crystal ball, and we have to look at individual cases. The other kind of resource that we have that's extremely important is that we have many alternatives to detention. In other words, we don't have to rely on money. We can rely on location monitoring, home detention, frequent visits by pretrial services, support services, hooking people up to drug programs, mental health programs, employment programs. We've learned that getting people jobs isn't as difficult as we thought. Helping people hold on to jobs is a little more difficult. So our pretrial services people actually hook people up with agencies that teach people how to dress for work, dress for interviews. The pretrial services people try to help them. For example, someone who's got a job and after 2 months the supervisor is saying, you're on the cell phone too much, or you're late, et cetera. They're able to provide that kind of support. How can they do that? Because they have a lot of resources. So that's the kind of thing that we feel that we have the luxury to do in the federal system. Not every federal court is the same. There are 94 different districts around the country. The average or the national pretrial release rate is about 50%, but that even includes people with very high risk. So I think I've gotten the signal that it's time to stop, so I think I'll stop there. But if you have any questions about how our system works and if there's anything that can be learned from it, I'm happy to answer them. Thank you.